We're rolling, so
Let's talk about child support motion to modify template. So, as you of course know, there's several reasons you might need to modify child support. Perhaps the amount is not high enough, the payor is making more money now, or maybe it's too high. Maybe the payor is your client and the payor lost their job, so we need to modify it down. Or maybe it's being paid to the wrong person because the children have been sent to someone else. Maybe the grandparents have taken over the children because one of the parents isn't doing well psychologically, or they're on drugs or something horrible like that. So we have on our template a checklist of things to remind you or your staff about when you're doing a child support motion to modify. First thing is to send a letter to opposing party. So if this applies, to send a letter and ask them if, without sending formal discovery, they'll just provide you with current income information. Of course, if you're within a year, you may have trouble modifying child support. If it's been 3 years and it was court ordered originally, then you're going to have a pretty good chance if the change has been 20% or more. So before you bother, with the expense of formal discovery, we just suggest sending a letter saying, hey, will you provide us current income information? And that's assuming you know who the lawyer is, that they had a lawyer at the divorce or the underlying suit, and that you know who the lawyer is. If you're asking for above guideline support, of course, that's a little trickier. And if you want it, you have to plead for it. So you'll want to look at the Texas Family Code 154-123, and it lists all the factors that the court can consider. But the court can't consider them if you don't plead for it. So it's just a reminder to put that in your pleading if you have that issue. The other thing that you have to plead for, your threshold requirement, is to show a change of circumstance. And so there's a reminder that if it's been 3 years and 20%, like we talked about, that is a change of circumstance only if the prior order was ordered by the court. It does not apply to agreements, so you want to be aware of that. That's a common misunderstanding. So another tip that we have here is guidelines. The court will apply guidelines in most cases. There is a slight break, and a reminder here that there's a slight break if the payor has children that they're legally responsible for, other children. If there's a slight break if the payor is paying for health insurance for the child. So you may need to send discovery. Let's say that they will not voluntarily provide you with that information. Then here's a way to assign someone to prepare discovery. And then you'll want to draft the actual motion. So you'll want to track the language in the statute. If you have to track the change of circumstance language, and if you're relying upon the 3 years and 20%, you want to track that. If you're not, you don't need to include that in your pleading. And then you can assign someone to draft a proposed order. Of course, it's always the best practice to have at your hearing a proposed order, and maybe the judge will just sign it, which would be very exciting, and then there'll be less to fight over later. Okay, what if you're defending against a motion to modify? So your client is the payor and they're asking that your client pay more, and you don't want to pay more. Maybe it's not even been a year, so the burden of proof is higher, and the change of circumstances is going to be harder to show because not much time has passed. One thing to consider if you're defending is a motion for summary judgment on the issue of change of circumstance. And we have a good sample motion for summary judgment in Smart Legal Practice for you to look at on this topic on child support. And I think this is something that's worth looking at. The change of circumstance burden is not any change. It has to be a change that relates to the requested relief. So, for example, maybe there's been a change of circumstance that in this situation the person receiving child support has moved. Well, that certainly is a change of circumstance in a basic understanding or a non-legal understanding of a changed circumstance. Their circumstances have changed. But that isn't necessarily anything that has anything to do with the payor situation. And they're really the one whose change of circumstance is relevant, because the statute doesn't look at what the circumstances are generally of the person receiving child support. They're looking at what the circumstances are of the person paying child support. Now, there's some exception to that, obviously, but that's going to fall more in the realm of if you were asking for above guideline child support and we were looking at the circumstances surrounding the child, maybe the child's disabled or has some serious medical conditions that are expensive, which would be a more common reason to go outside the guidelines. But otherwise, they're mainly looking at the payor circumstances. So has their job situation changed? Are they making more money or less money? Have they lost a job? That would be the change of circumstance that would be most relevant in a child support fight. And so I would consider that and consider filing that motion for summary judgment. Now, most cases are not won on a summary judgment motion because the burden is so high. The court has to say, if everything the other side said is true, would they still lose? That's hard in family law. But it does give you a chance to, one, make your argument twice essentially to the court, because now you've made it at the summary judgment level, the court has seriously considered it, and you're going to make it again at the trial level. So you're really emphasizing your point, which I think is helpful. You kind of get two bites at the apple that way. And two, it forces them to show their proof on change of circumstance in advance of trial. So it's a way to get that information very solidly from them and a way to talk about this twice before the court. So if you do prevail, great, but if you don't, it's still not a loss because you've had the advantage of arguing it twice to the court, and it's really going to stand out in the court's mind. So that is the template for child support motion to modify.